Since the merger in 1966 with the AFL, NFL Commissioner Pete Rozelle had sought to establish a formal cross-ownership policy. NFL owners were slowly growing more irritated by Kansas City Chief owner Lamar Hunt and Miami Dolphins owner Joe Robbie because they also owned soccer teams at the time. This was when the North American Soccer League, also known as the NASL, was becoming more and more popular. The New York Cosmos were consistently drawing attendances of over 70,000 people at Giant Stadium and were arguably the most popular sports team in the culture, often partying with the biggest celebrities. The NFL owners felt that Hunt and Robbie were helping the NASL grow as a detriment to the NFL. The NASL was still a young league struggling for financial success, and Hunt was a key stabilizing presence. As the 1970s progressed, a few NFL owners became increasingly outspoken on this topic, mainly Leonard Toews and Max Winter, owners of the Philadelphia Eagles and Minnesota Vikings, respectively. They complained publicly that the NASL teams in their home markets were taking away business from them, and that Lamar Hunt's efforts to promote the NASL were having a negative effect on their NFL teams and the league overall. So at the annual owners meeting in October 1978, Pete Rozelle officially proposed a new section to Article 9 of the NFL Constitution, which would institute a formal ban on NFL owners and their relatives from owning any capital investment in other professional sports teams. The NASL quickly filed suit in the Southern District of New York, seeking a permanent injunction alleging that the new cross-ownership rule violated the Sherman Antitrust Act. In February 1978, Judge Haight issued a preliminary injunction prohibiting the enactment of the proposed amendment, as the NASL would have been irreparably injured. Following a lengthy trial, Judge Haight issued a decision on November 17, 1980. While he found that the purpose of the proposed NFL rule was to suppress competition, he denied relief on the ground that the NFL was a single economic entity and was therefore exempt from the Sherman Act. The NFL thought they had got their hands on the coveted single entity status, but the Second Circuit Court was confident in reversing this ruling on appeal. The Second Circuit Court made it quite clear that actors in a joint venture seeking exemption from antitrust had repeatedly been rejected by the Supreme Court, and that the Sherman Act had been held applicable to professional sports teams by numerous lesser federal courts. They had even dropped citations of 18 cases to emphasize their point on this. With single entity exemption off the table, the court had to apply a rule of reason analysis to determine if the NFL's proposed rule violated the Sherman Act. The existence of less restrictive alternatives is of vital concern when conducting a rule of reason analysis, yet the NFL did not present any alternatives at trial. The court deemed that the proposed rule's net effect was to substantially restrain competition and that any positive effects on the marketplace were clearly outweighed by its anti-competitive purpose. Therefore, it violated the rule of reason. In addition, the circuit court ruled that there was in fact a separate market for sports capital and skill. Due to the many tangible hurdles in purchasing a professional sports team, there's only a certain pool of eligible owners. In fact, when the NFL added 2 expansion teams in 1974, the franchises were awarded to ownership groups with individuals who had experience as owners in other sports. Back then, it was millionaires who were eligible to buy sports teams, but today it sadly seems only the billionaire class is in the marketplace. The court also noted that these cross-ownerships had already been in place for years, and there was no clear detriment to the NFL as a league. For these reasons, the Second Circuit Court reversed the lower court ruling and remanded the case to the district court with directions to enter a permanent injunction prohibiting the NFL's cross-ownership ban and to consider damages. So the NFL's proposed ban on cross-ownership was struck down in the court of law. An interesting tidbit from this case is that a young Jeffrey Kessler, a Columbia Law School grad, worked on this case for the plaintiff's legal team. He has become one of America's leading sports lawyers, having represented the U.S. women's soccer team in their battle for equal pay, and he is currently representing the NASL in their lawsuit against the U.S. Soccer Federation. Only in 2018 did the NFL officially allow owners to own another professional sports team in the same home market. And of course, the lasting legacy of this case is evident in how we now see numerous owners of sporting properties owning multiple teams, including 7 from the NFL.